noisy. Okay, let's talk about hardcore law, and let's do a 3-minute recap of the course of Mr. Milo, because private law, of which corporate law is a part, consists of 5 main avenues. And the first avenue is the combination of corporate law and family law. The law around the actors within private law. So private law has as first perspective, it is a area of law dealing with the rights and obligations of persons, and we have 2 flavors as was introduced to you in the other courses. You have private individuals and you have legal persons. We will discuss that at length, but a fiction of law that assigns to a piece of paper, a fiction, the same rights as a human being. And then rights are as in obligations based on the contract or pertaining to assets, to valuables, to goods, or to property. So the second main topic of private law, and often called property law, is the area around what type of objects of value, from an economic perspective, are the concern of law. And that includes immovable property, houses, plants. That includes movable property, chairs, tables, laptops, bicycles. That includes all kinds of intellectual property, copyrights, patents, trademarks. And that includes other intangible property, like claims on someone else, who in a bundle can be sold to other owners. And that is especially in the haute finance, in the highbrow financial world economics, let's say the main asset that you deal and that you trade in bundles of contracts. And from a corporate law or from a private law perspective, that is then part of property law in the broadest sense of the word. Those are basically the 2 relevant areas of law that you need as a society. But the funny thing is that the moment you have property, there is this desire to transfer the property to someone else. And the mechanism to transfer the ownership of an asset, of property, from one owner, one person, to another person, that mechanism is called contract law. So contract law is just a means, a split second, to change the ownership relationship. This is something lawyers and jurists have difficulty in accepting, because for most jurists, contract law as such is a thing. But contract law as such is not an aim in itself. It's a means to facilitate transfer of ownership of property. So in the debate, what legal field is most important, the real answer is property law is the most important area of law. But here we have something that happens in your field as well. There is some value in the type of person that deals with the topic. And somehow property lawyers allowed the others to outshine them. So somehow contract law is much more sexy and more dynamic and the like. But I would like to emphasize that the real stuff is in property law. When you're an owner of your firm, and you have to make your balance sheet. We will talk a lot about balance sheets, and I will expect that you know when I talk about equity and assets that we understand each other, and I will test that upcoming Thursday. And so when you look at your assets, that is a question of property law in the broader sense of the word. But in the debate and in the look and feel, contract law lawyers are much more dominant. I'm in a sense a contract lawyer, but I acknowledge I exist only because of property law in the first. And then there's another way of exchanging property, and that is in a non-voluntary fashion. And that is where liability is the key word. But also liability law, in Dutch aansprakelijkheidsrecht, or another way, non-contractual liability, is also just a mechanism to transfer ownership of money from one person to another person. We will discuss liability law from the perspective of corporate law, from the perspective of the manager, the board of a corporation, am I liable or not? Or the shareholder, am I liable for obligations of the enterprise, yes or no? And liable means nothing more than the mechanism that you potentially lose assets. And lose assets is another word of that there will be a new owner of your assets. So the obligation to pay money by operation of law, tort law is another key word, is like contract law, just another mechanism that ownership of assets move from one person to the other. And then, last but not least, private law deals with a minority amount of cases where this transfer of ownership does not go smooth, that there is a dispute. So the fifth element of private law is dispute settlement, litigation law, or all kinds of other names for, let's say, the sort of fancy Hollywood television series type of phenomena that we see each other in court. And that is important because the judge, that is the driving force in private law in that fifth chapter, decides on yes or no liable, yes or no obliged to pay money based on a contract, yes or no transfer of ownership of property. Property, think of money, among others. And because of that role, we in the legal field, so jurists, attorneys at law, focus on dispute settlement. Not from the perspective, oh, how nice to settle our dispute. No, from the perspective, if we understand how a judge will decide, we can advise our clients accordingly before the dispute. So all the legal statements of this course are inspired by this fifth chapter of private law, how the situation would end up in a court of law. And that means that in your narrative and in your elevator pitch, you will learn to include words like, well, if this would be in court, if a judge would decide on this matter, then based on this legal rule, this will be the outcome. And based on that narrative, based on that mental process, we are able, in the advisory spheres, to settle all the disputes outside court, applying the same reasoning, but without the judge as a sort of nanny supervising that similar decision. And so we use the narrative of litigation and the words of the judge and the other regulators to retroactively make statements how a contract should look like, how a damage of your product should be dealt with on a voluntary basis, how the ownership of property should be assessed and registered in balance sheets from a corporate perspective, etc., etc. So this is private law, and we position corporate law within this picture. And then we have obviously the sort of societal regulatory realm around it. We will discuss that in week 8. But the hardcore corporate law, company law, law of undertakings, all synonyms, deal with this. And the good news is, this did not change in the last 5,000 years. And the Romans had the same 5 topics, and all jurisdictions, one way or the other, have this type of topics. And when you look at law school, then apart from public law and criminal law, the menu is these 5 courses. Or 6. And you did already contract law. You did already litigation, I believe, in a way.
European Union.
Within the realm of European Union law, where you discussed court cases of the European Court of Justice. Property law, did you do property? Yes, a full course on property law, or? And now we add corporate law, and each time sort of the litigation pops up. And with Mr. Milo, you also did non-contractual liability, isn't it? As sort of mirror of contract law, or not? 20%, 30%?
More, I think, in the other third year course you capture the liability aspect more.
And which one?
I forgot the name, but I lost it.
Who helps? Who helps? In which court? In which course was tort law, non-contractual liability, sort of?
Economics and law.
Okay. Okay. Yeah. Yeah. So law and economics.
Yeah.
And you already did that last year?
Yes.
No. Some people have this.
And who did law and economics? And who planned to do law and economics this year? Okay, in the next course. Okay, there's already a lot of law and economics type of thinking in this. Okay. Last but not least, I repeat myself. Ultimately, we look at property law from a sort of balance sheet perspective. Is this on my balance sheet or is it on your balance sheet? That's the question. And then, Kraakman, the 5 basic principles. Let's introduce them right now. Let's dwell on them in the workshop, and let's then in the upcoming weeks, week 2, 3 and 4, deal with 2 or 3 of them separately. So this is the overview of all 5, and then we will discuss them in detail. First of all, the aspect of the legal person. The corporation as an actor in the economy, which is a fiction of law, a creation of mankind, in the sense that it is not a natural phenomenon. So it is not sort of biological phenomenon, a corporation or company or an enterprise, in the sense that the law assigns rights and obligations to. If you look at a corporation from a person perspective, then you get a whole range of topics for free. One topic is, how does the birth of the corporation go? What are the requirements? What are the steps? What are the legal ramifications, etc. Then in a life cycle approach, gentlemen, in a life cycle approach, the ultimate last question is, how do legal persons, undertakings, disappear? In the metaphor of a natural life, how do they die? What, from a legal perspective, is a discontinuation of a legal person? How does it look like? And there you have words, you know, like bankruptcy or insolvency or these type of words. Chapter 11, and we will discuss. like with litigation, the first concern of corporate law is about how do I birth a legal person and how do I maintain that legal person in good standing or in good order, that it does not die. So for contract law and tort law, the ultimate man at the door is the judge. And for corporate law, the ultimate man at the judge is bankruptcy. So many legal rules and many narratives, many discussions in a enterprise are looking at that sort of doom scenario that you may go bankrupt based on wrong decisions, etc. And we link that type of thinking to topic number 1, being the corporation as legal person. The second topic is corporate law from the perspective of the owner of that legal person. Now that a legal person is an actor in the society, but like with robots, not a natural phenomena and not having human rights themselves, then like with chairs, like with buildings, like with intellectual property, you need an owner of that legal person. And that makes a corporation, in a sense, part of property law. Because if you discuss owners of the legal person, then apparently there's a sort of ownership relationship between, also known as the shareholders, and the corporation. And then the corporation as such is a asset. And that is how you know in advanced accounting that on the left side of the balance sheet there are the shares of the subsidiary corporations, and that is a Matrushka puppet or Droste effect phenomena that there's no end to it. So a human being can own a corporation, that corporation can own a corporation, that corporation can own a next corporation, that corporation can own a next corporation. And then all those corporations are two things. In itself, a full swing legal person, but from the perspective of the owner, just another chair. In the presentation, you will deal with corporations like Unilever and so forth, Shell. They have between 200 and 600 subsidiaries. Like a building with many tables and chairs. So those are two sort of descriptions of a legal aspect of a corporation. A third key aspect is delegated management. And that is already a choice. Because we will discuss in the workshop a few forms of enterprises without delegated management, sole proprietorships, but this course deals with big companies. Because then you have all the features, and if you know all the features, you can also deal with enterprises missing a few features. So we look at big companies to the extent that, and that is how chapter 1 starts, they look at stock market listed corporations as the most complete type of corporation that exists. Well, and in such organization, the third characteristic is that they have delegated management. That means that not the owner is running the place, but conceptually that different people are running the place, are making the day-to-day decisions. And then you have a legal person, management, and owners. And then you have all kinds of agency problems we will discuss during this 10 weeks between those sort of bodies or organs or whatever name we will give to them in the upcoming week. Last but not least, obviously, as an owner you can decide to wear two hats. Then you are owner and your own manager. So this model does not exclude that, for instance, Mr. Heineken Senior was shareholder of Heineken Limited, but also the director. But those are conceptually two different roles. And then we move to the fourth topic, and that is the topic of limited liability. I use on purpose the same icon as I used in the recap of private law. The tort law, the non-contractual liability icon, and that is the fourth theme. In the sense that from the perspective of the enterprise itself, the legal person, the manager, and the owner should not be liable for unlawful acts. From the perspective of the actor, private individual, you want the legal person, the management, and the owner be liable if you engage with that enterprise. From the perspective of the government, you want that there is a fair balance between liabilities, between third parties and the legal person, management and ownership. Why? So that there is harmony and no conflict. Meaning that corporate law concerns itself with the design of those liability relationships and arrangements. And with design, we mean, in the regulatory sense of the word, down to earth, whether there is a legal rule in the statute, the corporation is not liable, or the corporation is liable. Full stop. Yeah. Design is very simple. We can redesign corporate law overnight. Just take a text editor, make new rules, put them in the official gazette, get democratic support, and then you have new corporate law. And so that is made by us. And that is this interaction. When you, for instance, look at the liability topic, then the key issue is how much liability will owners and managers accept, and if you go beyond that, then nobody wants to involve in business. Or if there is no liability whatsoever, how much unrest you get with creditors, employees and other stakeholders who do not want to contract and purchase the goods and services of the company anymore. That is the balancing act in the liability. And I repeat myself, liability of management, liability of owner, and liability of the corporation itself. And then one of the main rules that in the last 600 years appear to be a very strong rule from a capitalistic perspective is the concept of non-liability. And that is what most forms of legal enterprises look like or are named after, with the word limited, limited liability, or LTD, or variations of that. In Dutch, besloten vennootschap. And in German, GmbH, Gesellschaft mit beschränkter Haftung, which is German for company with limited liability. So already in the name, we put in one choice in topic 4, and that is, let's see what happens if they are not liable. And what happens? Then owners want to invest their money in those enterprises, and managers, you want to aim at a career that you end up in the boardroom and make those decisions. And non-liability means that not your assets on your private balance sheet are at stake if something happens. We will discuss that. And last but not least, a key feature of modern corporate law, let's say of the last 100 years, is the transferability of the ownership or of the shares. Transferability of shares. Making the whole affair of an eternal nature. So the initial establisher or creator of the legal person invests in the enterprise as a aggregate of capital and labor, or all kinds of other economic theories you can put on enterprises. And the transferability topic means the mechanism that the initial investor can transfer the ownership of their shares to a new person. And then the enterprise itself continues to exist. And that makes enterprises, corporations, immortal. So they do not die unless you miss it. And this is a very important feature of corporate law and all the designs behind that transfer. How should you design in a private deal or on a public stock market?